Divorce is the legal end of a marriage. When a divorce is filed, the parties may be asked by the court to attend counseling and mediation to resolve their differences amicably without trial. This video will deal with legal principles and provide an overview of court processes. Detailed information is available online from the Family Court homepage on the Subordinate Court's website. The law on divorce is in the Women's Charter, which can be found online. Information on court procedures, brochures, and forms are also available. Alternatively, visit the Help Center at the Family Court. There are reference materials and forms, and the Family Court staff will provide general assistance on court procedures. To apply for divorce in Singapore, you or your spouse must be a citizen of Singapore, be domiciled in Singapore, that is, you treat Singapore as your home, or have been habitually resident in Singapore for at least 3 years. In addition, 3 years must have passed since your marriage, unless there are exceptional circumstances. The spouse filing for divorce, called the plaintiff, must give details and prove at least one of 5 facts leading to the breakdown of the marriage. The other spouse, called the defendant, must inform the court of whether he or she objects to the divorce. In the vast majority of cases, both spouses eventually consent to a divorce based on agreed details leading to the breakdown of the marriage. The court may then grant an interim judgment for divorce. There are 3 main steps in starting the application process. Step 1. The plaintiff starts the proceedings by filing a writ for divorce, together with a statement of claim, a statement of particulars, and some other documents. After filing, the plaintiff serves these documents on the defendant. Step 2. The defendant has to file a memorandum of appearance within 8 days of receiving the writ for divorce. The memorandum of appearance is to inform the court of whether the defendant objects to the divorce. A defendant who objects to the divorce will have to file a defense to the divorce within 14 days. A defendant who objects to the divorce and also wants to make his or her own application for divorce will have to file a defense and counterclaim for divorce within 14 days. The plaintiff may then file a reply and a defense to the defendant's counterclaim within 14 days. The defendant then has 14 days to file a reply to the plaintiff's defense to the counterclaim. Step 3. When all the necessary documents have been filed, the plaintiff has to file a request for set-down action to formally ask the court for a hearing date for the divorce and indicate whether the divorce is contested or uncontested. All documents submitted to the court have to be electronically filed. If you do not have a lawyer, visit the Help Center or Family Court homepage to find out how to file your court documents electronically. If the plaintiff does not set down within 6 weeks of filing the writ, the court will write to both parties to attend a status conference to find out how the case is progressing. Parties representing themselves should attend the status conference. If a party continually avoids court appointments, the court can proceed to hear the case and make final orders without the party. At the status conference, the court will consider the issues and may direct parties to go for counseling or mediation to resolve the divorce if they are unable to reach an agreement on their own. If parties reach an agreement on the divorce, there will be an uncontested divorce hearing. Parties generally do not have to appear in court. A large majority of divorce cases are uncontested and parties are able to obtain interim judgment without going to trial. If they have also resolved their divorce ancillary matters and filed a draft consent order, the court will grant the ancillary order at the same time as the interim judgment for divorce. If parties are not able to reach an agreement on the divorce, there will be a contested divorce hearing. This means the parties will have to make a sworn statement and appear for a trial in open court. Then the judge will decide whether to grant an interim judgment for divorce or dismiss the application after hearing the evidence. After the interim judgment, the court will deal with the matters ancillary to the divorce. If there are minor children, the parents are required to consider the parenting and care arrangements for their children. If both parents agree on the care and parenting arrangements, the plaintiff will file an agreed parenting plan. Otherwise, the plaintiff will file a proposed parenting plan for the other parent to consider. Under the law, the welfare of the child is paramount. Court orders on the parenting and care arrangements for the child are made in the child's best interest. The court will consider the wishes of the parents and those of the child if they are able to express their views. Both parents are usually given joint custody of the child, unless there are exceptional circumstances. Joint custody means that both parents are to be jointly responsible for major decisions affecting the child, such as health, education, and religion. One parent will generally be given care and control of the child, which means the child will stay with that parent who is responsible for taking care of the daily needs of the child. The other parent will have access to spend time to bond with the child. These care arrangements for the child are important to help the child know that he's loved by both parents and that he will continue to spend time and enjoy various activities with both parents. The care arrangements will depend on the age of the child, his needs, and his wishes if he is able to express his views. Matrimonial assets are assets that are acquired during the marriage by either party, and assets ordinarily used or enjoyed by both parties and their children. When dividing matrimonial assets, the court will consider the contributions by both parties, both financial and non-financial. The court will generally apply a holistic approach to achieve a just and fair division. The court will consider all the circumstances of the case. For the matrimonial home, the court may order that the home be sold and the net proceeds be divided between both parties, or that the share of the matrimonial home be transferred from one party to the other party. In some cases, the CPF funds used to buy the property must be refunded to CPF. If the matrimonial home is an HDB flat, check with the HDB on whether the flat can be sold or one party can buy over the flat. Maintenance is financial support. There are two types of maintenance. Maintenance for a former wife, payable by her former husband, and maintenance for children, payable by both parents. It is the duty of each parent to maintain his or her child. The court will consider all circumstances of the case to decide the amount of maintenance to be provided. The factors taken into account when deciding on maintenance are set out in the Women's Charter. Income and expenses are of course relevant in deciding on maintenance. If there are ancillary matters that are not resolved, the parties will make sworn statements on their assets, income, and their wishes for care and parenting arrangements for their children. There will be a hearing in chambers, and the judge will decide and make an order on ancillary matters. A hearing or trial is the last resort. Instead of fighting it out in court, parties should try to resolve their disputes amicably. It will save parties emotional pain, stress, and substantial time and money. Divorce is a painful experience, and a major life transition. Counseling is a forum for parties to deal with the life-changing aspects of a divorce and complex emotions such as feelings of grief, failure, fear, anger, and uncertainty. Mediation gives parties an opportunity to find their own solution to settle their legal dispute. The family court provides counseling and mediation at the family resolutions chambers in the family court and at the child-focused resolution center. In court counseling, the family counselor will meet with parties together or separately to help them to identify their concerns and address their differences. The family counselor will also assist parties to explore alternatives and make future plans for themselves and their children. During mediation, a judge mediator meets with the parties together and separately with their lawyers to help parties to negotiate a possible settlement without going for a court hearing. Court counseling and mediation is confidential and without prejudice. This means that if the case has to proceed to trial, a different judge will hear the case, and the new judge will not know what was discussed during the counseling and mediation sessions. The Child-Focused Resolution Center, or CFRC, was set up to help divorcing parents who are required by law to attend counseling and mediation to deal with issues concerning their children. When there are children involved, it is important for divorcing parents to understand that even though they are no longer husband and wife, they will always be parents to their children. This is a tie that binds them for life. It is natural that these may be emotionally difficult times, but parents must remember to protect their children from parental conflict. The CFRC program gives parents an opportunity to resolve their disputes as early as possible. The judge and family counselor will help the parents create a suitable parenting agreement that focuses on the future and allows their children to have meaningful relationships with both parents. Work together as co-parents to identify the unique needs of their children and ensure their children's best interests, and provide parents with useful information to reduce the negative impact of the divorce on their children or deal with future parenting challenges. The CFRC program will help parents understand the impact of divorce on their children and adapt to their new roles and new relationship as co-parents to their children. If parties come to an agreement during counseling, a judge will grant the court order according to the agreement. This court order is known as a consent order. A large majority of cases are settled amicably without trial. Before starting court proceedings, there are different ways to seek information and help for yourself. To find a lawyer, you may wish to access the Law Society of Singapore website to obtain a directory of lawyers or a list of legal clinics in Singapore where lawyers volunteer their time to provide free legal advice. You may also check if you qualify for subsidized legal services provided by the Legal Aid Bureau. The Singapore Mediation Center also offers mediation to assist couples to settle their disputes early and amicably. Family service centers are located island-wide. They provide an array of counseling and support services. There are many paths that are open to you. Seek help early to find the best path forward for yourself. In the family court, we help families in this emotionally difficult and trying time to move forward with confidence in their new lives.